Thanks, Kim, for that very kind introduction. Hey, Chip Cooper, Internet Attorney for FTCGuardian.com, #1 in FTC compliance training. Now, in this video, I'd like to explain the bonus that Kim is making available to all Engage Pro level members and up. And this bonus consists of a basic level membership in FTC Guardian. You need to know the benefits, and I'll explain them to you. And then second, you need to know that you have upgrade rights from the basic level membership to the pro level membership in FTC Guardian, and I'll explain what's involved there. And then finally, I'm going to provide some training that you can take advantage of right now in what we at FTC Guardian consider the hottest area on the internet right now, which is retargeted ads. If you're not involved in retargeted ads now or plan to be in the future, you're really missing out because they convert very well. And the topic of this brief presentation is 3 killer mistakes to avoid with retargeted ads. So what about this basic level membership, the bonus that you'll receive? Well, it consists of 8 documents which we consider to be the most fundamental documents that almost any online business might need to get started with FTC compliance today. The top 3 documents are the legal page, terms of use, and privacy policy. Now, the terms of use contains an option for taking advantage of the DMCA safe harbor from copyright liability, and there's also a separate document, a registration form that you would file with the U.S. Copyright Office. But probably the most significant document in this package is the privacy policy, and there are options that will enable you to create a privacy policy that is really tailored to your business model. So these are the documents that you'll be able to take advantage of as a basic level member, but you have the right to upgrade to the pro level membership. And when you do, these documents expand from 8 to, I believe it's 85 or 86, and I lose count because we add new ones all the time. Now, these documents are not your typical cookie cutter, fill in the form documents. Instead, they involve what is known as rule-based document assembly, or RBDA, which I designed years ago for use in my law practice. In fact, these documents and the system for creating them is what I use every day in my internet law practice. And the way it works is that it simulates what you would actually do if you hired me as your internet attorney. I would ask you questions, and then based on your answers to the questions, I would create documents. And that's exactly what the software does. It asks you questions, and sometimes the question you're now answering depends on your answer to a prior question. There's a logic tree underneath the whole process. And then when you get to the end of the questionnaire, you hit submit, and the software goes to a database of thousands of clauses, pulls the ones that are indicated by your answers, numbers, assembles them into the proper order, numbers them appropriately, and then spits out a really, truly customized document. And the process only takes about 5 seconds. But that's not all. In addition to the 85 or 86 documents, you get what FTC Guardian is really known for, and that is training in FTC compliance. Now, the basic level of training is through 3 to 5 minute videos on topics that apply to just about everything you do in the operation of your business. Do you use testimonials? Of course you do. There's a very simple explanation of the rules. Do you outsource the creation of a book cover for a Kindle book or for an image to use as a social media post or on your sales page? Of course you do. We explain all of those rules to make sure that you can operate your business legally and effectively, because in many cases we're talking about the U.S. Copyright Act, and in the outsourcing situation, unless you understand the rules, your outsourcer is going to own the copyrights in the work product rather than you, even though you paid for it. So that's the basic level of training in the pro level membership, but there's a higher level which we're extremely proud of and which we get rave reviews from our members about. And that is, twice a month we offer 2 Google Hangouts in areas that represent new developments that affect the way you need to operate your online business. So where else in the world can you go twice a month and get a 20-minute presentation about new developments that affect your business, and have 10 to 15 minutes to ask me, a full-time internet attorney, questions live about that topic or anything that's remotely related to it. There's nothing else like it on the internet. So these are the benefits of the pro level membership, and we certainly encourage you to consider upgrading. So now we get to the training. 3 killer mistakes that you need to avoid with retargeted ads. So let's go to the slides.
Okay, top 3 killer mistakes to avoid with ad retargeting. First, a little housekeeping, presented for informational purposes only. It's not legal advice, and no attorney-client relationship is created. Okay, we all know the cliche that you can always learn from your mistakes, and so you shouldn't worry about making them. Charge straight ahead, and they're all learning experiences, right? And generally speaking, this is pretty good advice, and I believe in it completely. But with respect to FTC compliance, it's terrible advice, because a single mistake can be life-changing. It can completely change your life, and this is what it might look like in terms of a life-changing event. This is a clip from the top part of a complaint filed by the Federal Trade Commission against an online business known as Apply Knowledge. And you can see that in the left column here. But in the right column, what you see should make the hair on the back of your neck stand up, because when this was filed and this order was signed by the federal judge in the U.S. District Court of District of Utah, essentially Apply Knowledge was shut down. And you can see in the right column, temporary restraining order, asset freeze, appointment of a receiver who's supposed to go in and replace the business owners and take over the business. So if this isn't a life-changing event, I don't know what is. But then you add to it not only the fact that they can shut down your business, but they can go after you individually in terms of personal liability, because the FTC has a very easy route to your personal assets, your bank accounts, your home, your car, that sort of thing. All they have to do is list you underneath the entity name here on the left column if you participated in the advertising or the unfair trade practices, usually involving some type of advertising, or if you managed it. It's very easy to list you there, and your personal assets are at risk. A really significant thing to consider, right? And you see here in this slide that below those entity defendants, you simply list the individuals, which would of course be your name and anyone who works in the business, and that results in personal liability, the ability of the FTC to reach your personal assets, right? And here is a clip in the order regarding the part of the order dealing with asset freeze. You see the highlighted language: temporarily restrained and enjoined from transferring, dispersing, spending, etc. all of your personal, your funds, your accounts, and any other types of asset you might have. This is what really gets online business owners sort of crazy, because you wonder, if an asset freeze is imposed on you, how do you pay your mortgage? How do you pay your bills? You obviously are in a very difficult position, and you don't want to be there. That's the bottom line. Okay, so what about these 3 killer mistakes for ad retargeting? All right, mistake number 1, failure to properly disclose the collection, use, and sharing of information for ad retargeting. Obviously very important. And there are a couple of cases I want to present very briefly to you. The first is the Federal Trade Commission versus UPromise, a 2012 case. And here, the basic idea is that the FTC went after UPromise for what is known as affirmative misstatements, which is a fairly fancy term, simply meaning that they made certain statements and assurances in their privacy policy, which, by the way, the FTC views as enforceable promises, but they simply didn't keep these promises. One was that a toolbar would infrequently, in quotes, collect personal information, which turned out not to be true. Another was that they would, quote, remove any personal information prior to transmission. Again, not true. So because these statements were made which were not true, then the FTC brought suit, and the result was the destruction of all data collected. Your list, etc., was gone. Okay, the FTC again in 2012 against Epic Marketplace, and here the claim is different, and this is really significant because instead of the failure to honor their promises, so to speak, in their privacy policy, they merely failed to disclose sensitive information regarding the collection of information for marketing purposes. So here, just your failure to disclose how you collect, use, and share information, and this would apply to retargeted ads, is a deceptive trade practice actionable by the Federal Trade Commission, and in this case the settlement resulted in the destruction again of all the information collected. So there are at least two very important results in your failure to make these disclosures. The first one is you can get banned by the ad platforms, and we're talking primarily here about Google and Facebook. They've got in their terms of use their own requirements for disclosures, and if you don't make them in your privacy policy, you'll get banned. But even worse than that, of course, if you don't make the required disclosures that the FTC requires, you can get sued. And these early cases, as indicated by the two cases we've just taken a quick look at, involve only data destruction. I'm convinced that the future ones will impose massive fines, which is typical with FTC cases. Killer mistake number 2, failure to disclose opt-out opportunities. Now, in addition to explaining the way that you collect, use, and share information for purposes of ad retargeting, you're also supposed to disclose ways to opt out of this process. And again, the platforms have rules. Google has a specific link. Facebook requires you to notify them to remove a consumer from your Facebook custom audience, a consumer who wants to opt out. And then there are some trade associations that provide opt-out tools. The Network Advertising Initiative, NAI, and also the Digital Advertising Alliance, also known as DAA. Each of these websites provide tools for opting out, and those links are very helpful in complying with the opt-out requirements, both for Google and Facebook and also for trade FTC compliance. And then killer mistake number 3, failure to adapt to the rapid pace of legal developments for ad retargeting. Now, there are a couple of important facts here. We know now that retargeting has transformed monetization on the web. It's woven into the very fabric of the internet today, and it happened relatively rapidly. And if you're not yet involved, as I've indicated, in ad retargeting, you will be soon. And a final fact, FTC regulators are going to continue to struggle with the rapid growth of tracking tools and methodologies, right? So there's going to be bottom-up regulation and also top-down, we'll cover in just a second. But bottom-up means that the marketers at the lower level, in this case, as indicated by the two cases, UPromise and Epic Marketplace, there'll be examples, and there's going to be a tsunami of transparency and disclosure-related cases as the FTC struggles to figure out how to strike a reasonable balance between privacy advocates who don't like retargeted ads, who view them as a privacy invasion, right, and those who do like them. There is a fine line between that kind of regulation. Now, I'd like to point out that in the FTC Guardian Pro level membership, there is a supplemental classification of documents. And in this supplemental classification, there is a brand new privacy policy that we have only uploaded fairly recently that deals with all of these required disclosures. The disclosures required by the ad platforms, Google and Facebook, as well as the disclosures required for or by the Federal Trade Commission, so that if you're involved or plan to be involved in ad retargeting, which you should be, you need to seriously consider an upgrade to FTC Guardian's pro-level membership, because we have in the supplemental category of documents a brand new policy that will provide these disclosures that are required right now. Also, there is going to be top-down regulation, and there is a brand new report that came out in 2014 regarding data brokers, and the title is Data Brokers, A Call for Transparency and Accountability. You can download this report, the PDF file for it, by simply Googling Data Broker FTC Report 2014, and you can review that report yourself. But here's the idea here, the general idea behind the report, and that is that at the top level of the retargeting ecosystem is a group of companies known as data brokers. And the FTC was really not aware of exactly what they were doing until fairly recently. And once they made their study of a certain group of data brokers, as indicated in this 2014 report, they were sort of surprised at the level of aggregation of data sets that they collect from persons and from collectors at the lower level, and then they use data mining techniques to profile consumers and then sell these profiles back down to the lower levels to marketers for purposes of ad retargeting. That process was not fully known, and the implications of it not fully known until the FTC came out with this 2014 report. And you can rest assured that there are going to be new regulations from the top down that follow this 2014 report. So there's going to be from the bottom up types of regulations and from the top down. So what does this mean to you? It means that if you become involved in retargeted ads, you really need, it's going to be a rapidly moving target. You need to not only be in compliance right now, but stay in compliance as these regulations come down, and they're going to come down fairly rapidly. So you'll need an opportunity to stay current. So my recommendation and our recommendation at FTC Guardian is you'll either need to retain an experienced advertising attorney who can guide you along the way with ad retargeting, or your other option, the next best option, is to upgrade to the FTC Guardian Pro Level membership, because we have right now a privacy policy that makes the required disclosures, and we will keep you up to date with all of the new developments. And the primary mechanism that we use are the Hangouts, the Google Hangouts, twice a month on very specific targets, usually 20 minutes or so by me as a presentation, and then 10 to 15, 20 minutes for Q&A. So where else can you go on the web and ask an internet attorney who practices full-time, as I do, questions about these current topics, including ad retargeting? We will keep you up to date on all of the new developments, as well as we will update our privacy policy accordingly. So that's it for now. Thank you very much for attending and listening to this presentation.